Good morning. Welcome to an oral argument session of the 5th District Court of Appeals via Zoom. I am Judge Nardella. I'm joined today by Judge Evander and Judge Harris. Please keep in mind that today's oral arguments are being streamed live as well as being recorded. With that in mind, we are now at the 10 o'clock session for case number 21-232, State of Florida versus Alyssa Ann Abachi. Counsel for appellant, how much time would you like in rebuttal today?
Morning, Your Honor. The state would request 7 minutes for rebuttal.
7 minutes. Okay.
Thank you.
I will try to help you keep track of that, but if you can keep a watch of the clock as well, that would be helpful.
Absolutely, Your Honor.
With that, you may begin.
Thank you. May it please the court, my name is Richard Pallas. I represent the state of Florida. The state is seeking reversal of the trial court's order granting the defendant's motion to suppress. To briefly summarize the facts, while law enforcement was engaged in a DUI investigation following a traffic accident, a witness approached and asked if he could provide the Mirandized defendant with his cellular phone, which had recently retained counsel. Law enforcement did not allow the witness to hand the phone to the defendant. The defendant did not ask to speak to counsel. Now, after a hearing, the trial court suppressed anything that any evidence that was obtained after law enforcement learned of counsel's telephonic presence. It's the state's position that.
Let me ask you this. Help set the parameters, if you would, and see if I understand this right. The motion to suppress was based on an alleged violation of the due process clause. Is that correct?
Yes, Your Honor.
Okay. However, the trial judge did not rule on that. The trial judge granted the motion based on the Sixth Amendment rather than the Fifth, Miranda. Is that correct?
Well, I'm not certain whether the trial court granted it, Your Honor, on Fifth or Sixth Amendment. Obviously, there's right to counsel under both. If I remember the order correctly, they specify just Miranda. Not due process specifically, or Mcadams, one of, I believe, the chief cases we'll be discussing today.
Yeah, this court finds that the troopers violated the defendants under Miranda when they did not allow the defendant an opportunity to speak with her attorney. So at least to me, that suggests Sixth Amendment.
My understanding, Your Honor, is that Miranda is stemming from our Fifth Amendment due process right.
Okay, go ahead. I'm sorry.
Oh no, I apologize, Your Honor. But either way, Miranda and the state of Florida's interpretation of its own constitutional amendment for due process, those are two separate protections, with Florida granting more powerful protections. So of course, if the state argued only that Miranda was not an issue in this case, because it's the state's position that that holding is completely incorrect. The state obviously recognizes that under Tipsy Coachman, with the facts that are here, if the due process clause of Florida's Constitution, as applied by the Florida Supreme Court in Mcadams, and as this court has also applied the interpretation in Greenwich or Greenwich, of course, this court would have means to affirm. But it is the state's position today that this is not one of those narrow situations where the state constitution's due process clause should warrant suppression of this evidence.
What's your argument on the Miranda issues first?
Oh, Your Honor, our main issues on Miranda is that here the defendant never invoked. The holding of Mcadams does not state that Miranda is the reason that you must always tell them that counsel is there. You need to actually, it's crystal clear, invoke your right to counsel or your right to remain silent. And further, there's been plenty of case law talking about how field sobriety exercises are non-testimonial. This is physical evidence that is being gathered. We don't have a situation as such as Allred from the Florida Supreme Court in 1993, where it was testimonial because it was the content of what was being said in reciting the alphabet in reverse from, I believe, W to C or the other way around. And of course, we have Justice former Chief Justice Rehnquist's concurrence in the Pennsylvania v. Muniz case, pointing out specifically that as that holding applies, such field sobriety exercises as the walk-in turn, the nystagmus horizontal test, and I believe the one leg stand, those are that is physical observations versus testimonial evidence. So our main argument with Miranda is that the state should be able to overturn this order because the defendant never invoked her right to Miranda, and Miranda did not apply in the first place. The only way that possibly Miranda would have been offended would have been with testimonial evidence. But as demonstrated at this hearing, I believe all of her comments on her rear-ending the other vehicle in the traffic collision that triggered this investigation, that was before Mr. Ingersoll, the witness who retained counsel, approached. It was my understanding that this was right at the onset of the field sobriety exercises, based on the record at the time that this, I would say, the asterisk in our record that shows whether or not do we have a due process violation under the Florida Constitution, or do we have Miranda violations? And again, there was no invocation. Unless this court has other questions on Miranda, I'd like to get into the due process issue, if that is fine. Primarily when I believe all the way going to the Halliburton courts, Halliburton 1 suppressed a certain custodial issue where someone wasn't told that their counsel was there. Now, there was a dissent from former Justice Stevens in a case, Moran v. Burbine, that this court ultimately adopted in considering the Halliburton decision. In the second Halliburton, they went and said, well, we can give stronger due process connections. Law enforcement, the same way they can't conceal evidence that would be exculpatory, they can't conceal the fact that your attorney is trying to reach you. This brings us to 2016 with Mcadams. The Mcadams holding, it's the state's position that this is a narrow holding. They basically stated that a suspect being questioned in a non-public area, law enforcement is required to notify that particular suspect that counsel is present and counsel's purpose. Now, in Mcadams, that was a defendant who was in an interrogation room regarding murder accusations, and counsel had arrived. No one would let counsel from the lobby into the actual interrogation room, some ways away. This decision was also applied by this court later on that year in Greenwich. And in that case, once again, we had another case where counsel was retained, but this time it was the defendant's stepfather. The defendant's stepfather called, spoke to a receptionist, but never spoke to any law enforcement officers. And this was vicariously shown that law enforcement knew and should have at that point alerted the defendant that counsel was trying to reach him. Even though counsel wasn't physically there, counsel was able to be there, of course, by telephone.
Are you conceding that this was a non-public area?
No, Your Honor. In fact, the state is arguing this is anything but a public area.
The vehicles were moved and blocked off and kind of isolated the defendant from the crowd that was there.
Well, Your Honor,
weren't free to come in that area, right?
Well, Your Honor, of course, they wouldn't allow Mr. Ingersoll to come over that area. Law enforcement's allowed to not allow people to walk in on an investigation, especially a DUI investigation, because that's both going to be an issue of officer safety, public safety, and let's be honest, the suspect's safety as well, depending on how those field sobriety exercises are going. I do not believe that this is the same situation as law enforcement taking someone into an interrogation room.
Well, let me ask you, if they had set up a perimeter 200 yards by 200 yards, would that be a non-public area?
Well, Your Honor, if there was the possibility that counsel also followed to that area and was still able to get to the defendant after those 2,000 yards.
Everyone's 200 yards away except for the police and the suspect.
Well, Your Honor, I
Police
believe
said
that.
no one is to get closer.
Well, Your Honor, I believe.
But they're not in a police station.
So in this case, Your Honor, just so I know our hypothetical correctly, we are moved 200 yards away with no one around, just us on a DUI Gilligan's Island, basically, officers and the
No
defendant.
one allowed to get within 200 yards. The police
Now-
said no one further can pass.
I mean, in situations like that, I believe this turns custodial, which is more of an issue with Miranda. And of course, in the dissent in
Now, my
McAdams,
question is it non-public?
in an area where you separate yourself from everyone, and there is, I would say, Your Honor, that I think that would be non-public, but for this reason specifically. And that's that law enforcement at this point is removing the defendant or the suspect from a public area and taking them to an area where the only way that this defendant is going to know that counsel is trying to reach them is by law enforcement themselves facilitating that interaction with the defendant. I mean, this could be possibly a series of a couple feet away if it's through a complete solid wall with only a telephone separating us, or as you say, Your Honor, 200 yards away. But I believe what will matter is whether counsel is capable of getting to the defendant without law enforcement's help. I believe under your hypothetical, that would warn us into a non-public area. But to extend that hypothetical to the same gas station where the defendants were parked, or where the defendant was parked after this accident had occurred, I believe would be an expansion of Mcadams. And I don't know when it stops at that point. In those situations, we would be putting a heavy burden on law enforcement, potentially compromising their safety and ability to protect the public safety. Because if, let's say, someone just asking someone to walk over to them and someone says, by the way, I'm that person's attorney, law enforcement is going to be thinking in their mind, is this a McAdams situation? Am I looking at state due process, or can I rely on Miranda right now? I believe that because this is so different from these cases of defendants either being in an interrogation room or a defendant who's in the psychiatric wing of a hospital with no way of getting to his attorney because the hospital staff won't let him get to them, as the Baskin case out of the 2nd District Court of Appeal. This is certainly not a situation where the defendant was questioned in a non-public area, thus warranting the state constitution's due process clause protections and right to counsel.
Mr. Paulus, in your initial brief, you say that the defendant was led to water, but she did not drink. Does your argument turn upon a finding that the defendant was capable of hearing that her attorney wanted to speak with her?
That's an alternative mode of our argument, Your Honor. Instead of me focusing on that for this oral argument, I believe that the fact that we're not in the non-public area is the most important part of this argument. But alternatively, if this was something of a non-public area, I believe we are now even more factually distinguishable from the cases of McAdams due to the fact that this defendant was within earshot. I don't believe that's whether we're on a subjective mode of whether she heard him or not, just because someone right next to her also heard her. But obviously I understand that the reasonable inferences will be taken in terms of upholding the order, which is why I want to focus more on the non-public issue. But based on
if your non-public argument fails, we disagree with that. Does McAdams control, or is McAdams still distinguishable?
It would still be distinguishable, Your Honor, because of the fact that now we're getting into these facts of the case. And this court has access to the same video that the trial court did. The trial court only found that there was that evidence was conflicting as to whether or not she knew that counsel was there available. I don't believe that a subjective standard applies to this. Whether one is inebriated or one is focused on field sobriety exercises or only concentrating on the law enforcement officer themselves, somebody started walking up just on the other side of the vehicle. The video shows that. Is
your argument, this argument, based on us making a finding that that the defendant did or should have heard the witness saying, I have an attorney on the phone?
Yes, Your Honor.
How can we do that as an appellate court?
Well, Your Honor, because the video is part of this, that is the possibility for this court to give a de novo view of that fact.
There's no audio on that.
That is correct, Your Honor. They said that something was wrong with the microphone and that, but I believe that it's the physical. If we take the testimony at trial, which is, of course, law enforcement saying I heard and the defendant saying she did not hear. But if we were to,
how many times do you think people have had in their life where they're standing next to someone and there's something going on, someone spoke or they're listening, watching a movie or whatever it is, and one person turns to the other and says, what did they say? And the person responds, they said this. I mean, that just happens commonly in life where one person hears something and a person standing next to them doesn't understand it and asks, what did that person say? I mean, that's certainly not an unusual occurrence. Would you agree?
Correct, Your Honor. It's not an unusual occurrence, but I believe in these situations, we're turning law enforcement into a messaging service, of which they are not. Of
Mr.
course.
Paulus, just a reminder, you're at the 4-minute mark almost.
Thank you, Your Honor. Again, I believe that this argument truly turns on whether this was a non-public area. And by this court holding this was not a non-public area, Mcadams does not apply. The defendant does not get this right under due process of the state constitution. And defendant is only given Miranda in this area, of which she did not invoke. So there was no reason for counsel to tell her, did you hear that? Would you like to speak to this cell phone? Would you like to speak to this man interrupting a law enforcement's investigation of your DUI? In my opinion, diverting him from not interfering with this investigation is not the same as removing the defendant from the public to a place where the defendant can only reach her attorney if facilitated by law enforcement's intervention. If this court has no other questions, I'll reserve the rest of my time for rebuttal. Thank you.
Mr. Lefebvre, please proceed when you're ready.
Thank you, Your Honors. Good morning. My name is Michael Lefebvre. I represent Alyssa Abachi in this appeal. I'm going to delve directly into the public versus non-public and due process violation issue that stands before the court right now.
Before you do that, I do want to address the Miranda. I mean, would you agree that that was the basis of the trial judge's ruling?
I do agree.
All right. Now you quote in your opinion, excuse me, in your answer brief, you referenced the dissent for Moran versus Burbine as something that the Florida Supreme Court cited with approval in the Mcadams case, I believe it was. But in the majority opinion in Moran versus Burbine, didn't they pretty much indicate that the trial judge's ruling in this case would be incorrect? That the question you focus on is whether there's a waiver of Miranda and whether Miranda was invoked, and for purposes of Miranda issue, whether someone tried unsuccessfully to get to the suspect was not the relevant inquiry. Would you agree with that?
To a point. However, it's an interesting thing in Moran versus Burbine because the state, I would say, finds itself on the horns of a dilemma. For Miranda purposes, in Moran versus Burbine, the majority said basically when the defendant does things that the defendant does not know about. In Burbine, the defendant did not know his attorney was attempting to gain access. Therefore, the majority said because the defendant did not know of these things, how in the world could it impact that person's reasonable understanding of Miranda warnings and rights? So to the extent that the state claims here that my client knew that her attorney was attempting to gain access, Well, the Moran versus Burbine would say that's a totally different situation, and that would clearly impact someone's ability to understand and apply and actually utilize their Miranda rights. So to the
If the
extent
trial judge was to have found in this case that your client was unaware of the efforts of counsel to reach her, would you agree that Moran versus Burbine would strongly suggest that the trial courts could not find that there had been a violation of your client's Miranda rights?
Yes, I would say that Moran versus Burbine says that if she was unaware. Of course, the court found that there was conflicting, I think I'm quoting from the opinion, conflicting evidence on her awareness. The trooper said she didn't turn her head, didn't acknowledge it in any way. Miss Abachi in her testimony said she didn't hear. So, but
that's why you spent the majority of your answer brief on your tipsy coachman argument.
It is, and I would be, and I want to be forthright, of course, and say that my Miranda arguments are subordinate and secondary.
Okay.
So, with regard to the tipsy coachman argument, I would argue that Mcadams is, as the state has indicated, is based on the dissent in Moran versus Burbine, which says that police interference with a person's right to counsel is just egregious. It is misconduct. It is misconduct under the due process clause. Here, I will come back to this point, but unlike in some of the other cases where, particularly in Greenwich, where this court said, the police were basically, this was an inadvertent, they didn't let counsel speak to his attorney. It was some inadvertent thing where the detective didn't look at his cell phone to know that the attorney was attempting to get through, et cetera, et cetera. Here, the police specifically said to the attorney's proxy, get out of here. Now, I don't think that interference can get much more blunt than that. So I would point out that, Mcadams, of course, does say it has to be in a non-public place. My first argument with regard to that is something that the court has already alluded to, and that is that Miss Abachi was, quote unquote, taken to the other side of the building. She is separated from her companions. She is standing, not by chance, directly in front of the Florida Highway patrol car. Early on in the video that has been made part of this record, she attempts to walk away for a second. I think that's in the first minute of it. You see her take 3 steps and do a U-turn and get right back between the headlights. I would say that indicates she's not going anywhere. The police themselves said she was not free to leave. She's detained. And of course, there was a police car. There's a 3rd police officer in the video. So there are 3 police officers there around Miss Abachi. One is on the perimeter, and the other 2 are directly next to her, Troopers Juber and the investigating officer. So here, I would say she is as separated as she can be from the public. It is a de facto non-public place. I don't think the construction of brick walls and mortar make the slightest bit of difference. I would note that in Mcadams, Mr. Mcadams was brought to the police station voluntarily. He was told he was not under arrest. That means he can walk outside at any time. He enjoyed freedoms that Miss Abachi did not have. She was not able to walk outside this restricted area. Mr. Mcadams certainly could. He's free to leave at any time. The voluntary statement. So I would say that is a distinction without a difference. The state has said, well, this is a very narrow opinion in Mcadams. And I will say that Mcadams does say that questioning is in a non-public place. It does say that. It also says that the attorney has to arrive on location. In Greenwich, when the attorney appeared by cell phone, this court said that arriving on location criterion is not material. And I would say that the existence here of walls or a half wall or being in a cubicle versus an open door, closed door room, those sort of distinctions do not and can and should not dictate whether the police can simply tell attorneys when they have a person in front of them to get out of here.
Let me ask you this. You referenced questioning in non-public places. And so instead of the emphasis on the non-public places, let's talk about the aspect of questioning. Was this questioning, or was this the gathering of physical evidence as suggested by our opinion in Burns?
I would say it's a combination of both. Certainly, field sobriety exercises such as the walk and turn have physical components. Under Allred, cited in my brief, the counting portion of that is testimonial. The counting portion, to the extent that the police ask someone on the one leg stand to count to 30 with their leg up in the air, is also by thousands, I think, is that exercise is also testimonial. The courts have under Allred. However, due process, I would say, is not just testimonial as a Miranda issue. Due process would also cover the waterfront with regard to tests that the police may be asking the person to subject themselves to. Certainly, if an attorney, for example, in Mcadams, if the police were in there saying, listen, we only want a DNA, we only want a blood test or a DNA test or some other physical test, and the attorney were banging on the door and they were saying, get out of here. I again would say that due process covers the investigation, not just testimonial words, would be my answer.
Okay, but McAdams, did they have any language that went beyond interviews, or the facts that you agree with McAdams were based on an interview of the suspect? Is there anything in the language that we can rely on to go a step further and say it includes, McAdams extends to physical evidence, or is there anything in the language that says we shouldn't go, or
that opinion is
the first impression in that regard?
I'm sorry to interrupt you, Your Honor. The opinion is silent. It simply says that the motion to suppress is granted from the time that the attorney attempted to have access, which was something like 8 minutes, I believe, into the my memory is not good on the time of the suppression, but but I would say that a due process violation should not be limited to simply words or testimonial evidence. Rather, for example, if the police violate due process in any situation, a common one would be by objective entrapment, where the police conduct is egregious and they gain drugs from the person by their misconduct, which is the typical situation. And such a due process violation, of course, the drugs are suppressed and excluded. And that is the nature of, for example, an objective entrapment due process violation. Due process basically cuts off and because of egregious police misconduct, cuts off any fruits. It's a Wong Sun, fruits of the poisonous tree, I would argue. So here, I would further argue that, Your Honors, coming around full circle, that the police, under a due process Mcadams situation, they have to notify Miss Abachi, or the person of the attorney's presence and purpose. They didn't. And there's nothing to really indicate that Miss Abachi knew. I don't think it's, I would say that it is the lower court that is responsible for finding facts in that regard. Of course, in Mcadams, Miss Abachi's custodial status is irrelevant, but really, when we look at the underpinnings of Mcadams, and the underpinning of Mcadams in Greenwich finds itself in Justice Stevens' dissent, that police interference with the attorney-client relationship is misconduct. Here, whether by in this situation and the facts before us, by telling Miss Abachi's attorney to get out of here, I would submit that that's a due process violation in and of itself. But more to the point, they did not ever in any way tell Miss Abachi that of her attorney's presence and purpose. And the police were candid at the motion to suppress by saying, we weren't going to let her speak to her attorney under any circumstances until our investigation was complete. And so I
What
would.
were the troopers required to do in this case? I mean, they didn't know that there was an attorney on the phone, right? They just had one of your client's friends, Ingersoll, screaming, "Hey, I've got a lawyer on the phone." Do they have to go investigate that and make sure there's actually a Florida bar member on the telephone, or can they just ignore it?
Your Honor, I would say that is a Greenwich, the situation in Greenwich, somewhat, where the attorney called in by cell phone, and I wouldn't say there was an independent investigation by the receptionist in Greenwich where.
That's different. This is the middle of an investigation. They have to stop what they're doing and confirm that it's actually a lawyer on the phone.
I would say under Greenwich that they do, because in Greenwich, the police, the detective, this court found that it was really inadvertent. The detective said, "I didn't check my cell phone for messages from the receptionist." The receptionist sent the detective a message, there was a lawyer on the phone, and the detective never looked at it. And this court held, well, that good faith or some other excuse just didn't matter. All that mattered was that an attorney was attempting to get in touch with his or her client. And here, the lower court specifically found that an attorney was attempting to get in touch or to contact Miss Abachi while she was in the throes or in the middle of an investigation. So I think that the police have to do exactly, they have to do exactly what Mcadams says. They have to, because Mcadams holds that, that the police do have to interrupt their interrogation. They do have to, and the Florida Supreme Court specifically said that. We hold that, not interrupting an investigation or an interrogation is simply not going to be countenanced. And that's in plain language, Mcadams. So,
there's an attorney on the phone.
Well,
let's say this Mr. Ingersoll had a co-defendant on the phone that needed to talk to your client to tell her not to say something about the drugs in the car. I mean, the officer doesn't know it's actually a lawyer on the phone just because somebody's screaming there's a lawyer on the phone.
Your Honor, I don't think there's anything in Mcadams or any of the other cases that indicates what investigations that the police have to do. I can simply say that in Greenwich, this court held that an attorney on the cell phone was sufficient for the purpose of an attorney under Mcadams being on scene. So I think that the police could simply and very easily vet that phone call. by simply saying, okay, well, they can get on the phone and say, who are you? And get the credentials of the attorney, should they choose, and that would take a couple of seconds. But that, I don't think that's a major undertaking for the police. More importantly, I think that the police have to do what Mcadams tells them to do and say, ma'am, there's an attorney, Michael LaFay, on the phone. This is his presence and this is his purpose. And then the person can then say, well, example, yes, that is my attorney. Yes, I know that person. That is my attorney, or what have you. But the police can, I would say, do whatever 30-second vetting that they need to do, of course, in this situation, but they must.
Let me ask you this, following up on Judge Harris's hypothetical. A lot of times the due process issues, they're very fact specific. So for instance, if the police officer who received the call said, oh, I know Mr. Ingersoll, and I know he does this all the time with Attorney LaFay. So I knew that was the case. That would be one scenario. A different scenario might be, I recognize as the voice of the co-defendant. I knew it wasn't an attorney or calling for the attorney. So do we have enough facts here to rule on a tipsy coachman issue? Can we affirm on tipsy coachman without affording the trial judge the opportunity to make findings of fact specific to that issue?
The tipsy coachman's facts that the court found were in the lower court's opinion, ultimately quoting from the ruling that the troopers did not allow the attorney to speak to the defendant. And I would say that that is the finding by the court, that there was an attorney on the phone legitimately, and two, that the troopers did not allow Ms. Abachi to speak to that person, and that the troopers were informed that the defendant's attorney was on the phone. So I would say that, and this court finds that the troopers did not allow the defendant an opportunity to speak with her attorney. That said, those are the rulings by the trial court. There is nothing within with the record that the court has before it. It is, of course, not disputed that the troopers did not advise Ms. Abachi of her attorney's presence and purpose.
Thank you, Mr. LaFay. Your time has expired.
I see that. Thank you, Your Honors. Thank you for your attention to my arguments.
Mr. Paulus, proceed when you're ready.
Thank you, Your Honor. May it please the court, I have 3 points on rebuttal. First, just to go along with the comparison of this case's facts with Mcadams, this defendant was allowed to was not allowed to leave because there was reasonable suspicion she was DUI. We don't have an adverse finding otherwise. We don't have a ruling otherwise. And we have plenty of testimony from law enforcement saying she had glassy eyes, her speech was slurred, they could smell alcohol both in the car and on her breath. You're not going to let someone just walk away from a criminal investigation like this, not a DUI investigation, and just let her leave and danger the public possibly more. That's not going to happen. And while I focused on non-public, of course, Your Honor, Judge Evander, you mentioned questioning. This isn't questioning. Any of the questioning happened before the field sobriety exercises and before Mr. Ingersoll appeared with counsel on the phone.
Let me ask you this. What if counsel's intent was to simply tell their client, don't do the field sobriety test?
Well, Your Honor, that would potentially open up 3850 issues because, of course, that evidence would be used against her. But, of course, that would be whether or not it was better to have it.
That's a tactical decision. maybe that performance on the field sobriety test might be more damaging in the attorney's eyes, more damaging than saying, I'm not going to do it on advice of counsel. So, but the real question is, given counsel's effort to call the client, yes, there wasn't questioning in some regard, but, there is an arguably interference with the ability of the attorney to say, don't take the field sobriety test, or for the client to ask, should I take the field sobriety test? Yes or no?
Well, Your Honor, I believe that this comes more into, I believe the hypothetical Judge Harris had raised earlier with a co-defendant wanting the attorney to say, hey, don't let this person search their car.
Right. What if the attorney calls and the police officer knows it's the attorney, recognizes the voice?
Well,
So
Your Honor.
that's not an issue anymore. So I
Your
want
Honor,
to get to the point about whether, if there's interference with the, giving advice on whether to submit to the field sobriety test or not.
I believe as long as we're in a non-public area and this is questioning, not observations of physical coordination, then that's a situation where they know that they must relay it pursuant to Mcadams. But again, this is not a non-public area and we were not subject to questioning in this. So Mcadams doesn't control. For my final point, by holding otherwise, we're expanding Mcadams. I believe the defendant mentioned, the underpinnings of Mcadams. We don't apply underpinnings, we apply the law. And the law specifically states we hold Mcadams' right to due process under the Florida Constitution was violated when law enforcement failed to inform him that an attorney was retained by his parents. They then go in earlier stating that you must notify them of presence and purpose in a non-public area during questioning. I see that I'm out of time, but thank you for your time. And if this court doesn't have any other questions, I'll rely on my briefs and I ask that you reverse the order granting the motion to suppress and remand for further proceedings. Thank you.
Counsel, thank you both for your argument today. We are adjourned.
Thank you, Your Honor. If I could, of course, my thanks to the panel, but also my special regards to Judge Harris. Judge Harris suffered with my first years in practice some 30 years ago. So I'd like to just send my regards to him. Thank you. Good to see you, Your Honors.